The Philippine criminal justice system. But first, what do you mean of criminal justice system? Criminal justice system, or CJS, is a social institution and a system which attempts to meet society's need for law and order. Here in Philippines, the Philippine Criminal Justice System, or PCJS, is a process which the government follows when someone violates a criminal law. The PCJS depends on a due process involving the 5 pillars: the police, prosecution, court, correction, and lastly, the community. The process of Philippine criminal justice system starts with a police officer or law enforcer who is considered as the initiator or prime mover of the system. For example, a certain person had committed a crime. It is the duty of the police to file a complaint into the prosecutor. Upon receiving the complaint, the prosecutor will conduct a preliminary investigation to determine if there is a probable cause or none. If none, the case will be dismissed. If yes, the prosecutor will file an information to the court. Now, it is the function of the court to issue a warrant of arrest in order for the police to arrest the suspect. There are 2 types of arrest: the arrest with warrant of arrest, served by the police, and the warrantless arrest, or the citizen arrest. It is applied when the suspect is caught in the act of doing the crime. After the court had issued the warrant of arrest, an inquest proceeding will be conducted by the prosecutor in order to determine whether the suspect should remain under custody and will be charged in court. If there is a request of PI waiver of Article 125 of RPC, it will proceed to preliminary investigation and the process continue. But if there is no request of PI waiver, the inquest prosecutor will file an information to the court. Now, the court having jurisdiction of the case will schedule the arraignment for the accused to enter his plea, but the accused may file a motion to quash complaint based on an alleged defect in the complaint of information which can be cured by amendment. The court shall order that an amendment be made. Based on the ground that the facts charged do not constitute an offense, the prosecution shall be given by the court an opportunity to correct the defect by amendment. The motion to quash may be either granted or denied. The motion shall be granted if the prosecution fails to make the amendment, or the complaint or information still suffers from the same despite the amendment. Upon arraignment and plea of the accused, a mandatory pre-trial conference under the Rule 118 will commence to take up the following matters: plea bargaining, stipulation of facts, marking for identification of evidence of the parties, waiver of objection for admissibility of evidence, modification of the order of trial if the accused admits the charge but interposes a lawful defense, such other matters as will promote a fair and expeditious trial of the criminal and civil aspect of the case. After the pre-trial, the court issues an order reciting what has been taken and thereafter the trial to determine if the accused is guilty or not. If not, he will be returning to the community. But if the accused is guilty, correction will now come into place after judgment of conviction. The accused may or may not file an appeal to the next higher court exercising appellate jurisdiction. Correction or rehabilitation is divided into 2 approaches: institutional correction and non-institutional correction. There are 2 bureaus handling institutional correction: the Bureau of Correction, or BUCOR, for those who are sentenced more than 3 years, and the Bureau of Jail Management and Technology for those who are sentenced not more than 3 years. For the non-institutional correction or community-based correction, it is when the accused is sentenced to serve not more than 6 years of imprisonment. He may file for a probation. He may also apply for pardon, which is conditional or absolute, granted by the President. But when the accused served at least minimum of his indeterminate sentence, he may be qualified for a parole. After serving his sentence, it is presumed that the convict is already reformed and fit to be released to the community as a law-abiding citizen.